Chair, Mr Wallace, Mr Richardson, Ms Nolan, thank you for attending the committee. Mr Wallace, KPMG were auditors of Irish Nationwide in the time running up to the collapse, and it was KPMG that advised the government that it was going to have to pay north of €5 billion into the bank, or into the building society. You said earlier on today at this Finance Committee, and I quote, referring to yourself and Mr Richardson, quote, "We have no experience selling loan books whatsoever," end quote. And you have no elected mandate, obviously, to act in the public interest. Based on that, Mr Wallace, do you think it's appropriate that you should be making decisions that are harming tens of thousands of Irish citizens?
Which decisions do you refer to, Deputy?
To, specifically in this case, to not allowing mortgage holders to bid on their own mortgages.
Okay, so two things in relation to that. Firstly, that decision is following independent advice from PwC. It's not a decision that myself and Mr Richardson made independently ourselves. It's following the receipt of professional advice, having appointed independent advisors to provide that information to us. And the other thing is that nowhere within the liquidation of IBRC have we allowed any individual borrower to singularly bid on their own loans without any competition from any other party. And I think that's important to note because I think it's forgotten in the detail. And indeed, as I said earlier, many of the individual borrowers who have been allowed to bid for their own loans have not been successful in acquiring those loans. And hypothetically, if we had decided after receiving independent advice that we would allow the mortgage holders or the borrowers to bid for their own loans, it would have been a quite difficult practical exercise because we would have had situations.
Sorry, I'm sorry to cut across you, Mr Wallace. My question is towards your suitability rather than the process. KPMG were the auditors of Irish Nationwide and gave them a clean bill of health. You have said yourself here today you have no experience selling loan books whatsoever, and you clearly have no elected mandate to look after the public interest. In the context of those three facts, do you believe it is appropriate that you are making decisions that so seriously affect tens of thousands of Irish men, women and children?
Yes, I do. And in many cases, a liquidator goes into a business where they have no prior experience. And I'm not saying that's an analogy here, but what I am saying is that I think it's wholly and absolutely appropriate that we would make decisions based on advice from experts in a given field. And the sale of the loan book that we're talking about is one aspect of the overall liquidation. It is not the entire liquidation itself.
Thank you. I'd like to come to the voluntary adherence to the CCMA. You'll be very familiar with the Code of Conduct and Mortgage Arrears. This is it. And I'm sure you'll be familiar, Mr Wallace, with the sentence, Chapter 1. It says the following: lenders are reminded that they are required to comply with this code as a matter of law. Now, what we've learned today at the committee is that the IBRC, or Irish Nationwide mortgage holders, rather than being protected by law, as is the case of the CCMA, will be protected by a voluntary agreement that has no supervision, no central bank involvement, no sanctions, nothing in writing, no guarantee that mortgage holders can buy out their own loans, and no access to the financial ombudsman. Do you think that mortgage holders should be satisfied with the voluntary agreement that you have secured on their behalf?
Definitely, that only applies in the circumstances where the acquirers of the mortgage books are unregulated entities. And myself and Mr Richardson aren't involved in the legislative aspect of the country, so what we can do is simply do the best that we can in the circumstances, being conscious of the fact that our ultimate objective is to get the best price we can for the assets of the bank.
I appreciate that. I'm just reading back part of your opening statement, which says, "We are satisfied that the voluntary nature of this arrangement strikes a fair balance between the interests of the mortgage holders as well as the interests of the creditors of IBRC, which is the state, essentially, the majority shareholder." Do you believe that the protections under law guaranteed by this, compared to a non-existent gentleman's agreement that no one is willing to write down, that has no oversight and no sanction and no enforceability, do you think that the nationwide mortgage holders should be satisfied with that agreement?
I understand there's a difference between both, but as far as myself and Mr Rich is concerned, we were actually pleased as to what we achieved by yesterday evening, having had 2 weeks of discussion with the potential bidders.
Would you be pleased if you were an Irish nationwide mortgage holder?
That's a different question. I'm just saying that from our
Different
perspective,
question. I'm asking you that question.
in the context, all we can do is what we can do in the context of our role as liquidators.
I appreciate that. Would you be pleased, would you be satisfied if you were an Irish nationwide mortgage holder?
If you were judging us in our role as liquidators, yes, I would.
I'd like to follow up on some of the questions deputies have asked about the lack of it being a binding agreement. You stated earlier on that it is your professional view that if it was a binding agreement, it would lower the sales price. Can I put it to you that if a bidder would lower their sales price if it was a binding agreement, then they are de facto not serious about the voluntary agreement, because they are lowering their sales price only because they are going to be forced to comply with this so-called non-existent voluntary agreement?
I think, Deputy, just maybe a slight sort of just subtlety in that we have independent advice that if we made it a compulsory term of the sales contract, it would impact value. And from that perspective, it opens up a potential issue for myself and Mr. Richardson as liquidators.
It does, Mr. Wallace, but what you told this committee in the last hour, that it is your professional view that if these bidders were asked to sign a binding agreement rather than a gentleman's spoken agreement, that it would lower the sales price. Do you think it is reasonable to therefore infer that they are not serious about the voluntary agreement if they're saying we'll pay you less if you force us to comply with our voluntary agreement?
No.
Why?
Because
that is completely illogical, Mr. Wallace.
You're mixing two things together, Deputy. The first thing is that we have professional independent advice which says that if we made it a compulsory term, it would impact on value, which has an issue for us as liquidators. Having parked that to one side, what we did try and attempt to do, which we achieved yesterday evening following 2 weeks of discussion with the potential bidders, is to get a voluntary agreement to the commitment to comply with the CCMA.
Okay. Thank you. You say in your opening statement, and I quote, "In this context, it is important to note that the objective of the third-party purchasers will be to make a financial return on their purchase." We agree on that. You continue, "It is unlikely that this purpose could be achieved through actions which would make it more rather than less difficult for borrowers to comply with the terms of their loan agreements." I would put it to you that in many cases that is rubbish. Let me give you an example. Let's take a mortgage in arrears where there's equity in the house. Now, what a lot of the domestic banks are doing is they're offering split mortgages. That comes at a cost to the lender. So if, as I agree, that these hedge funds and whoever else is bidding are looking to make a financial return, then what they are likely to do is evict the family, take possession of the house and secure their equity. Is that a reasonable assertion?
Not if we've done a restructured deal with the borrower prior to the sale and the borrower ensures that they adhere to the terms of that restructure.
What if you haven't done a voluntary agreement or a
possibility? Yes, that is a possibility.
It is. Thank you. Mr. Wallace, why won't you let the mortgage holders bid on their own mortgages?
Well, you cut me off a little while ago when I was trying to start explaining that particular issue. Hypothetically, parking to one side, and we did allude to the opening statement to a number of issues which we've taken into account following independent advice as to whether or not we've been in a position to allow mortgage holders to bid on their own loans. But as I said, there are two, even if we decided to go down that road, there are two practical issues. Parking all of the other issues that have come into our decision-making process as to whether we could contemplate individual mortgage holders bidding for their own loans. Firstly, that right across the entire portfolio of loans we have, there's less than 0.2% of total borrowers right across the entire IBRC book that have actually had the opportunity to bid for their own loans. And they've bid for their own loans in a very competitive environment, allowing other qualified bidders in to bid for those loans at the same time. So that we have had no examples right across any book, and neither will we have any examples where we will be having situations arising where individual borrowers are the only party bidding for their loan, because that doesn't allow myself and Mr. Richardson to fulfil our duty of getting and standing over getting best price. The second issue is this. Even if we got down to the point of allowing individual borrowers bid for their own loans, parking everything else to one side, we'd have a very practical range of issues to deal with, because hypothetically, if we'd Mr. and Mrs. Murphy with their home in a particular road in a particular suburb of Dublin, we would then have the information available to anybody who actually qualifies as a qualified bidder, which is not that difficult to qualify as, who would be able to go in, look at all of the information in relation to Mr. and Mrs. Murphy's home, their payment records, the amount of their mortgage, how much they're in arrears, when they stopped paying, all of the details around their mortgage, and we think that would be an incredibly practical range of difficulties that would arise, even if we got to the point of getting the advice which says that it is practical to allow individual mortgage holders to bid for their own loans.
It would be possible to create an auction process whereby individual mortgage holders had the option to bid for their own loans at whatever discount is going to be offered to other people who ultimately are going to buy their loans. That is an eminently achievable auction process. Was any effort made to model that auction process?
Consideration was given, as we had given in any of the portfolios we put for sale, as to whether or not there was room for individual borrowers to be placed out on their own in a separate tranche. And that consideration was given here, as we did in respect of any other portfolio. Indeed, as we said in our opening statement, we actually corresponded with each and every mortgage borrower prior to actually commencing the sales process. We got 1,224 responses, and myself, Mr. Richardson, and indeed PwC actually read those responses and did take them into account in forming final views in respect of how this particular portfolio should be sold.
On the basis that many of the replies from the individual mortgage holders said, please let us bid on our own mortgage, and you are in no way letting them bid on their own mortgage, how exactly did you take their feedback into account in designing the process?
Well, actually, in fact, there weren't as many as you might have thought in terms of putting in bids for their own mortgages at the time. And we did take in a number of issues into account: the cost of running a process, the timing of it, as I said, the independent advice from PwC, the fact that we did not have anywhere else in the process a situation where it was only the borrower who were bidding for their own loans, the confidentiality of the personal information, the execution risk in actually following through and getting it complete. And again, as I said, and I don't want to harp on this, but our obligation to get best price for the assets from a company law perspective in IBRC.
Is there anything in the design of the existing process which reflects the expressed wishes of mortgage holders to bid for their own mortgages?
No.
Thank you. Let me give you an example of a gentleman who was outside the gates, keen to see you this afternoon. He owes €220,000 on his family home, and he's in arrears of €20,000. Now, I'm going to assert that the non-performing loans, which his is one of, could be sold for a discount of 50%. We don't know and you can't say, but they could easily be sold at a 50% discount based on international prices for these types of loan books. Now, his home is in positive equity and he's not going to be able to pay the $220,000 mortgage. So what is likely to happen is that you are likely to sell his mortgage to a hedge fund for about €110,000. That hedge fund is likely, completely unregulated, to knock on his door or write him a letter and say, we are starting repossession proceedings. It is likely that he, his wife and his children will be evicted from their home. Now, you could have designed a process that sold him and his wife their mortgage for $110,000 or even more than you're going to sell it to whatever random hedge fund buys these things. He would stay in his house, his wife and his children would stay in the house. What do you say to him and to the thousands of other mortgage holders who are looking at that sort of a scenario?
And then I move on. Mr. Wallace or Mr. Richardson?
I think it's a very difficult set of circumstances for that individual. If he's not getting traction from IBRC, happy to talk to you afterwards, and if he is in the process of getting a restructure done, happy to expedite that if that helps him.
What do you say about the fact that you're going to sell his mortgage at a price that he could afford to somebody else and not allow him bid on it himself?
Without interruption, or we'll have to leave the centre, okay?
We've
Without
taken
interruption.
independent advice as to how to sell the mortgage book, and we have to rely on that independent advice, taking everything into account. And as liquidators, in our duties as liquidators, we believe that we've done the right thing in that context.
Comment, Chair? We'll come back if there's time to the PwC report in the next round. This is very short, Chair. Appreciate your indulgence. Thank you. Mr. Wallace, I think you're in a very tough position. And I think Minister Noonan, in the same way that I believe that you were hanging 13,000 Irish families out to dry, I believe Minister Noonan, who is conspicuous by his absence, I believe he's hanging you out to dry. But I have to say that I don't think you're helping yourself. I think you've made the wrong decision. I think it's going to cause an awful lot of pain and suffering unnecessarily in this country, and we will come back if we have time later to the fact that you have refused to release a redacted version of the PwC report to this committee. Thank you, Chair.
Just before I bring in